I'll start with the sufficiency argument. Mr. Simonds was convicted of attempted aggravated rape. The reason that the proof in this case was insufficient to support that conviction was because the state did not establish that Mr. Simonds took a substantial step towards completing the offense of aggravated rape. The lack of a substantial step is what makes the proof in this case insufficient, and for that reason we'd ask the court to reverse that conviction. The proof in this case, and you'll see from the record, is for a case like this remarkably thin. There's very little evidence presented. There is testimony from Ms. Jones, there's testimony from her son, and there's testimony from the responding officer. The responding officer's testimony was essentially, I arrived on the scene, I didn't find anything more, I got a statement from Ms. Jones. So really what we have is her testimony, and her testimony is it as far as what Mr. Simonds actually did, because her son did not witness anything that happened. So her testimony is pretty sparse. What she establishes is that she's in this trailer with Mr. Simonds. He has a weapon of some kind. He tells her to take off her clothes, and there's a struggle of some kind. There's no real detail in her testimony about what that struggle consisted of. And then she escapes the trailer, police are called, Mr. Simonds is later arrested.
Okay, so under our standard of review, all evidence is viewed in the light most favorable to the state. So looking at what she said, what did she say about the zip ties?
Okay, so she says that at some point she felt something behind her hands like she was being tied up with zip ties. She didn't have anything like specific about that. I don't think they found zip ties. She just says she thought that might have been happening.
Okay.
But beyond her kind of vague and somewhat hesitant testimony on that, there's not really anything about the zip ties.
Okay, so there's that evidence. Take off your clothes, and then was there not a statement, you know this is going to happen? Yeah,
he says this is happening, I think, is what her memory of it was. He might have said that more than once.
And is it your position that the jury could not infer what this is under those circumstances? Disrobe, something about being tied up, and this is going to happen?
I'm not sure there is enough there for the jury to conclude that she was really going to be tied up, but taking it again in the light most favorable, I'll say all of that is true. I again think that is not sufficient to show a substantial step towards the offense of aggravated rape.
Can you give me an example what you think would be a substantial step without the rape actually occurring?
Certainly. So the cases that are discussed in the brief, primarily Fowler and Bullard, all have instances where a rape was not completed and it really wasn't even started. But the court found that there was a substantial step because of actions that the defendant actually took. So in the first one, or in Fowler, for instance, the defendant went to an undercover officer and asked him to procure somebody for the purpose of having sex. In the Bullard case, which is a few years later, the defendant disrobed himself in addition to the victim, asked her to get into a shower with him, and the kind of events preceding that all suggested or all indicated actions on his part that suggested that was his intent. Here what we have, though, is if after those facts that I agree at this point are undisputed, what we really have is the victim's assessment or subjective impression of what she thought might happen. So she says at 2 points in her testimony, and it's really the only points where the word is even mentioned, is I was afraid he was going to rape me. That's what she says, and there's no doubting the validity of what she's saying or even the truth of what she's saying. But her subjective impression of what he was about to do is not enough to establish that there was a substantial step that he took towards aggravated rape. And aggravated rape in particular requires proof that there is a specific intent to engage in unlawful sexual penetration. So it's more than just he had an intent to touch her in a sexual way. It has to be a specific intent to engage in penetration of her. And the evidence that they put on so far, or the evidence they put on this case, doesn't have anything about that. And it doesn't have anything really about Mr. Simonds' behavior during all of this. It has a lot of behavior showing that he committed a crime. His behavior with her was undoubtedly illegal, and he should be punished for that. But what it doesn't do is show...
Let me interrupt, Counselor. As far as his behavior, I thought the record reflected that he lured her into the trailer, that he stood between her and the door so she couldn't exit, that he told her this is going to happen, that he asked her to take her clothes off, which might aid and assist him in penetration if she actually got that far to taking her clothes off. That there was the lacerations on this woman's throat, and that the defendant fled the scene. Those are the actions that I'm aware of. Are there more actions that the defendant undertook?
I don't think there are really anything else that came out in this proof. He asked her to come into the trailer with him to assist him in some kind of activity. He then stands between her and the door to the trailer, and then everything else, that's an accurate recitation of what the proof showed.
You're saying that's not enough for the jury. Of course, it was a jury question. You're saying that's not enough for the jury to decide what his intent was.
That is not enough for them to decide that he had the specific intent to commit an aggravated rape. I think there's a lot of evidence in there suggesting, well, this might have been a kidnapping. This was an assault. But the only thing that brings the word rape, and certainly aggravated rape, into it is her impression or her fear of what might happen. But that really wouldn't be any different than if she said, I thought he was going to rob me. Everything else is the same. Every other fact is the same. I don't think that's enough to get you to aggravated robbery, because it's just her assessment of what she thought he was doing. What the state needed to put on was to elicit from her proof about what he was actually doing, what his behavior actually was that would suggest what his intent was. And because they didn't do that, and I couldn't say why, all we're left with are these facts that they aren't great. They certainly show bad behavior on Mr. Simonds' part, but they don't show that he had the intent to engage in unlawful sexual penetration with the victim. And without that proof, the evidence is insufficient. Again, the evidence might have been sufficient for other offenses, but the offense they charged and the defense that the jury came back with a guilty on, that's the one that the proof does not support.
The way your brief and the state's brief too is laid out is sort of in a narrative form, and not necessarily about this witness testified to that or so forth. I can't tell from the briefs if your client testified or not.
He did not.
He did not. So there was no defense proof. This was all based.
There was defense proof. It just did not come from him.
Okay.
So his mother testified on his behalf. So the background of this is that the victim, she worked at Mr. Simons' mother's restaurant in Anderson County.
He was someone she knew. She volunteered to take him home. Is that what I
So
recall?
she works at the restaurant. He was there, I think, just because it was his mom's restaurant, and he needed a ride home. And it was closing time, so she just gave him a ride home. They picked up her son, I guess just to take him home. And then they stop at his house. Son stays in the car. I think he's playing video games or, being a teenager. Mr. Simonds and the victim go into the trailer.
So I guess what this boils down to, at least on this issue of sufficiency, is you don't think a reasonable juror could find that saying the things he said, conducting himself the way he conducted himself between the door and the house, or the victim, the knife, this is going to happen, take your clothes off, that a reasonable juror couldn't conclude from that a rape was about to happen?
I do not think that they could conclude that he had the specific intent to engage in unlawful sexual penetration of the victim, which is That requires very specific proof about what was on his mind at the time and what he did to take a substantial step towards doing that. Now, that's just a...
Well, let me ask you something. I'm trying to figure out, short of a completed act, what would be a substantial step that would show what's in the defendant's mind beyond a reasonable doubt?
I think the Bullard and Fowler cases illustrate exactly what's required to show. So in Bullard, when they talk about... Bullard's actually illustrative of this because in that case, the defendant takes the victim, or is repeatedly strikes and humiliates the victim, demands that the victim take off her or his clothes, I believe, and then the defendant himself takes off his clothes and then orders the victim to get into the bathtub. And what this court said was, that's really close. I said, this is a really close case, but under those circumstances, we think that's enough for the jury to get there. Even though I think the fact that the court was concerned about was, well, the defendant in that case was not in a state of arousal, and they were like, that does not matter for this purposes.
What did the defendant get convicted of in that case?
I believe it was the same thing that was charged in this case.
Aggravated rape?
Well, attempted aggravated rape. And so the court's analysis was about substantial step. Was there a substantial step taken towards committing the rape?
What's the difference in that case to our case?
I think the biggest one would be that the defendant in that case took off the clothes himself, took off his own clothes, and when he's beating and humiliating the victim, there was an element of, frankly, sexual sadism, it seemed to be from the opinion that was going on, and ordering her into the bathtub, I think, that suggest that something else is going to happen when he is naked, she is naked, and they're going to be in that part of the house. What we have here, though, is just his behavior that is, there's assaults where he strikes her, there's arguably confinement. They did charge kidnapping in this case. And that's what they could prove off of his actions. But if they're going to prove intent, or to prove attempt and attempted rape in particular, they do have to show more about what was in his head, primarily because once we're talking about the world of attempt, and if there was a substantial step, the main challenge for the state is showing what his intent was. And the only way they can do that is with his words and his actions. And I don't think the words that they've got and the actions they have suggest anything about an attempted rape. They suggest some bad behavior, they suggest an assault, they might suggest a kidnapping, but they don't suggest that he had the intent to commit a rape in this case. And without that, there is not a substantial step towards, or not enough to establish the element of a substantial step.
Even when he made her lie down?
I don't believe that happened in this case, that he made her lie down. There's a struggle, and then she gets away. But I don't know if it was he made her lie down. She at one point believed he was striking her, but even then, her memory or her testimony on that was not particularly clear. Right. And some of that might have been because of the questioning. When you're getting into the record in this case, this was kind of picking a jury to a verdict in, by lunch level trial. So they didn't ask that many questions of the alleged victim, and they didn't ask many questions of the other witnesses in this case. And that might be the problem, that they just didn't ask enough about what exactly it was Mr. Simonds was doing. But based off the record we have, I don't think that the facts that we agree are, at this point, it's going to be taken in the state's favor. Those are not enough to show a substantial step towards the specific offense of aggravated rape.
Was it enough to show any criminal offense, attempt to commit any criminal offense?
Certainly. I think there's an assault there. So the way it would have to go in this particular case, because they did charge aggravated kidnapping, he was acquitted of that. So in this case, the way sufficiency analysis, the way I understand that it goes is, if the evidence is insufficient to support the conviction offense, attempted aggravated rape, this court can then go to the lesser included offenses and see if the evidence is sufficient to support a lesser included of attempted aggravated rape. That's permissible. I don't believe the state has argued for that in this case. I'd be happy to address that in a supplemental brief. Like, is there some lesser included offense of attempted aggravated rape?
I wasn't really asking you about lesser included. For all I know, the state didn't charge the right offense.
Oh.
I was asking you what his actions, what would support, what conviction would be supported by his actions in this case?
It's interesting. I think the actions the evidence would support convictions for the offenses he was acquitted of, which is a strange situation. That does not often happen, but I think the proof that they have, he confined her, again, in the light most favorable to the state. He was acquitted of these offenses, so we have to kind of take that aside. But if he had been in the light most favorable to the state, he confined her in the trailer, he used a deadly weapon, and she suffered injury. That's enough to show a kidnapping. And in that case, an aggravated or maybe even especially aggravated kidnapping. But that the jury acquitted him of that offense does not equate to a conviction for aggravated rape. Each offense is analyzed separately, and each offense requires proof of each element. And while they might have put on enough proof to meet those kidnapping charges, they didn't put on that proof to meet the rape charges. And that he happened to be acquitted of the kidnapping charges does not all of a sudden elevate the proof that wasn't permitted or wasn't presented to make this a rape conviction. But I don't think I have anything really more on that particular issue, so I'll turn real quickly to the closing argument point, because I'm about to run out of time, I think. Yeah, it's saying stop. So if I had to just do 30 seconds on the closing.
Absolutely.
This case is remarkably similar to the Cawthorn decision that the Tennessee Supreme Court decided in 1999. In that decision, the prosecutor used the word evil somewhere between 15 and 20 times, and the Supreme Court said that type of language from a DA is absolutely improper and should not have been done in that case. Here, the opening of the closing argument was evil and evil heart. Those are the first things out of the prosecutor's mouth when he stands up to a closing argument. And unlike the case you heard earlier today, there was an immediate objection. And the court said overruled without any explanation. But if the court compares the prosecutor's language, in this case to Cawthorn, and sees how similar they are, and how close this case otherwise was, this would be an issue or a situation where if the court finds that there is sufficient evidence, the problems with the closing argument mean that this case should go back for a new trial with a proper closing. With that, I'll save what's little left of my time for rebuttal.
Thank you, sir.
Good afternoon, Your Honors. May it please the court. Garrett Ward on behalf of the state of Tennessee. Your Honors, this court must affirm the defendant's conviction for attempted aggravated rape because the evidence rather amply supports this conviction and because the state's closing argument is not so patently improper that it's the type of closing argument that demands reversal. And I'd like to start, Your Honors, my time with the sufficiency issue, and in particular, I'd like to start with the words of the defendant and then follow those up with a discussion of his actions. The words of the defendant are, "This is going to happen, Rachel. I have a knife. This is happening. This is going to happen." The defendant says this to Rachel Jones, the victim in this case, after he, under false pretenses, sort of lures her into a camper that he's living in, after he arms himself with a knife, positions himself between Ms. Jones and the door, and after he tells Ms. Jones to take off all of her clothes and lay down on the floor. Then, when Ms. Jones begins to struggle against him, refuses to comply with his request to get naked and lie down, at that point, he tells her that this is going to happen. Your Honors, any reasonable trier of fact would be well within their rights to conclude that what Mr. Simonds was telling Ms. Jones was going to happen, what this was was the offense of rape, and in this case, it's an aggravated rape. He's accomplishing it with a deadly weapon. Those are essentially the facts of the case. Those are the defendant's words and actions. Under our standard of review for sufficiency of the evidence, all evidence must be viewed in the light most favorable to the state. So it really means that this court's inquiry is limited to two things. Viewing the evidence in the light most favorable to the state, is there a proof of sort of a specific intent to commit the offense of aggravated rape, and is there proof of a substantial step? And Your Honors, the answer to both of those questions is yes. Dealing first with intent, I don't think that my friend on the other side or that this court can or should ignore the words of the defendant and how they were received by the one person who heard them. Certainly, sort of a subjective impression of the defendant's threats is not on its own, might not be on its own sufficient evidence to support the conviction of aggravated rape or attempted aggravated rape. But we don't just have her subjective impression of his words. We have his words and the context in which they are given as vividly described by the victim in this case. These aren't words said in a vacuum. These aren't words, this is going to happen. These aren't words that are unrelated to what the defendant has done. What he's done is he has, at knife point, ordered the victim to disrobe and lay down on the floor. Your Honors, that is entirely corroborative of a specific intent to unlawfully sexually penetrate the victim in this case. And that's really what we're concerned with here when we're dealing with sufficiency of the evidence for attempted aggravated rape is that evidence of a specific intent. And Your Honors, admittedly, it is circumstantial evidence of a specific intent, but that is hardly the odd case. It's rather the unusual case where a defendant's intent is sort of established by sort of a black letter proclamation that I am going to do something. Certainly, this case would be rather easy if the defendant had announced to the world, I'm going to rape Rachel Jones. But that's not what's required for there to be sufficient evidence of attempted aggravated rape. What he did do, order her to get naked, order her to lie down, tell her that this was going to happen, all while holding a knife to her throat. That is sufficient evidence on the question of intent. And as for a substantial step, not to sound like a broken clock, but I'd point this court right back to much of the evidence I've just discussed. There's evidence of multiple substantial steps towards the offense of aggravated rape in this case, from his initial actions in sort of luring her into the camper under false pretenses, him pulling a knife on her, him holding the knife against her throat, him ultimately taking her to the ground. There were some questions on that in this case. What Ms. Jones testified to is that at some point during the struggle, the defendant sort of smothers her with a pillow or a blanket, and they fall to the ground. So there is testimony in this case about the defendant transforming or continuing his sort of verbal actions, his verbal threat that this is going to happen. He continues that threat with physical contact with the victim in this case, both in the form of the knife, the pillow she discusses. She does specifically say that he tried to bind her hands with. She describes them as zip tie things. There's no uncertainty in her mind that he tries to bind her hand with something, and she specifically describes it as a zip tie. So we have this really ominous threat and then repeated instances of the defendant trying to use his physical might to accomplish the offense of aggravated rape. There's evidence, albeit circumstantial, of his intent. But Your Honors, in looking at all the testimony in this case, frankly, the issue of sufficiency is not a close call. There was ample evidence to support the jury's verdict in this case as regards attempted aggravated rape. If there are no further questions on the sufficiency of the evidence, I'll turn briefly to the closing argument issue in this case. And Your Honors, as I understand the argument my friend on the other side has, it boils down to the contention that this case is remarkably similar to Cawthorn. And Your Honors, I would encourage this case to, or encourage this court to look at the words of the prosecutor in Cawthorn. There is one similarity between Cawthorn and this case, and that's the use of the word evil. It begins and ends right there. What we don't have in this case, and what we do have in Cawthorn, is this repeated use, not just of the word evil, but the repeated description of the defendant in Cawthorn as the evil one that is accompanied by biblical references and a reference to a Rolling Stones song, establishing that by the evil in the prosecutor means Satan. The prosecutor means the devil. So the prosecutor is making a specific religious argument in Cawthorn. We have none of that here. The prosecutor does that.
What exactly did the prosecutor say in this case?
Certainly, Judge Ward. What the prosecutor in this case says is, first, that sort of a general statement that some men have evil in their heart. A few lines of transcript later, the prosecutor says that on the night of January the 6th, and I'll apologize if I'm not word for word quoting here, but on the night of January the 6th, which is the night of the attack, that Mr. Simonds had that evil and he displayed it.
So you're saying there was more than one reference to evil in the argument, and that was spread out, and it wasn't in the same sentence?
Your Honor, I would hesitate to say where exactly the period falls in this sentence. They're within, I think the entire challenge portion of argument in this case is about 5 lines of transcript. I might be over or underestimating that by a couple, and it might be contained in 2 sentences, but it's certainly one thought that is expressed a single time in this case. Versus Cawthorn, where I believe, if my recollection of Cawthorn is correct, the phrase "the evil one," which again is a clear allusion to Satan, is used 14 times and is present sort of at the beginning, the middle, and the end of the argument. Here we have, admittedly, the use of the word evil. I think the word is used 3 specific.
The word is not good. But how many times it was used and the context in which it was used is an important consideration for us to look at.
I believe in this case, if my recollection is correct, I believe it's used 3 times. One time is used very generally, just sort of saying some men have evil. It's used 2 times more in relation to Mr. Simonds. And I would agree with Your Honor's assessment that overall it's perhaps not the platonic ideal of a word for a prosecutor to use during an opening statement, or pardon me, during the sort of opening of a closing argument. But we do have a pretty stark difference between this and Cawthorn, namely 3 times just at the beginning versus sort of a pervasive theme of the defendant acting as the evil one. That is used 14 times, so at the beginning and middle and end of the argument in Cawthorn. And I'd go on to note that there's more going on in Cawthorn than just the use of the word evil. The prosecutor in Cawthorn makes some statement along the lines of, like, the evil one appears throughout history, and the defendant is just sort of an incarnation of him. And what the Tennessee Supreme Court said in the Cawthorn opinion is that clearly what the prosecutor is doing there is saying you should hold this defendant responsible for all of the evil done by this evil one, which again, thanks to the explicit religious arguments made by the Cawthorn prosecutor, we know to be a reference to Satan. That's simply not what we have here. The prosecutors making, really when we look at the context of their statement here, they're making primarily an argument that is characterizing a set of actions the defendant took on the night of the attack. Admittedly, they use some forceful language to describe those actions. The language they use is evil. But the word is used and then it's dropped. We don't have this pervasive theme. We don't have the prosecutor time and again sort of directing the jury back to the word evil, and that is an important difference between this case and Cawthorn. So, Your Honors, I'd suggest that this argument is a forceful argument, but not necessarily even an improper one. But, Your Honors, even if this court is inclined to say, look, the use of the word evil is just too much here. This argument is improper. I'd suggest to this court that under the judge factors, which are sort of the rubric this court uses to judge whether an improper argument is sort of so severely improper as to mandate reversal, that under consideration of the judge factors, reversal isn't required here. Sort of running through those really quickly, what judge tells this court to look at, among other things, is sort of the intent of the prosecutor and the context of the prosecutor's statement. Both of these two factors weigh sort of in favor of the state's position here that reversal wasn't required. The prosecutor makes a very brief statement, makes an allusion, discusses the word evil, uses the word evil, and then moves on, doesn't go back and hit it. So we don't have a prosecutor here like we do in Cawthorn, where the prosecutor's overall actions in the closing argument suggest to us their intent is to distract the jury from deciding the case on the law and the facts, but is instead just engaged in some process of inflaming the jury's passions. We don't have that here. That's not the intent that the record reflects this prosecutor had. So that weighs in favor of not finding reversal. So too does the curative instruction given by the trial court in this case. There's not an immediate curative instruction given, but both in the court's preliminary instructions at the outset of trial and in its concluding instructions, the court does instruct the jury that it must decide the case solely on the evidence, that sympathy and prejudice can play no part in their deliberations, and that statements and arguments of counsel are not evidence themselves. So that's another consideration that judge sort of points this court to consider that is in favor of not finding reversal. I'd also suggest the strength of the state's case as to the evidence on attempted aggravated rape, which is a consideration under judge, suggests that reversal isn't required here. The case is quite strong. We have very specific, very detailed testimony of the attack, at least as specific and detailed of a testimony as you can give when you're describing an attack where there are multiple attempts made to suffocate you and a knife is held to your throat. We also have some corroborative testimony just of the victim's testimony and the part of her son's testimony. We have a 911 call made immediately after the attack. And the story is rather consistent between these three things. Admittedly, there's much more detail in her testimony at trial than in what her son says or in the 911 call. But really, Your Honors, the Tennessee Supreme Court has said in no uncertain terms that reversal of a conviction based on improper closing argument is reserved for only the most severely improper arguments. And consideration of the factors laid out in judge, which are sort of our guiding lights for trying to determine which closing arguments are the ones that are the most severely improper. Consideration of these factors leads to the inescapable conclusion that this is not one of the cases where the argument is so severely improper that this court should find reversal, something which the Tennessee Supreme Court has said should not be lightly done and should only be done in the most severely improper cases. Unless this court has further questions, I would ask that you affirm.
Thank you, sir. I believe you have a couple minutes left in rebuttal.
Mr. Ridley, can you tell me what exactly the prosecutor said?
I sure will. That was going to be my first thing. So the theme of the state's argument was evil, and I'll just quote what the prosecutor opened his closing argument with. None of us know the evil that some men possess in their heart. There is no way we can know that by looking at them. There is no way we can know that by engaging. But we all know that there is evil in this world, and some men have evil in their heart, and Chris Simonds has that evil. So that's awfully close to a Sunday morning speech.
So was that one sentence or two sentences?
Let's see.
And 3 times referenced the word evil.
It is 3 sentences. I mean, that's the court reporter adding the periods because he's just talking. But yeah, that's 5 lines of transcript, and it's the first 5 lines of the closing argument. So
is that the only place?
That's the only place where he uses the word evil. But the opening of a closing argument is really where most attorneys are going to lay out what their theme is. And if they're going to lay out their theme as we all know there is evil in the world and some men have evil in their heart, we know that that's what the DA thinks the theme of his case is. And because of that, this can't be dismissed as, well, he only said it 3 times, not 15 like Cawthorn. Well, Cawthorn said, not only is this bad, it said we're explicitly cautioning DAs going forward about using this type of language. Cawthorn was over 20 years ago. Everybody should know at this point, we shouldn't be using the word evil in our closing arguments, and we certainly shouldn't be using the phrase evil in men's hearts and evil more broadly than just talking about one specific defendant. He's talking about evil in the world generally, which is exactly what Cawthorn said not to do.
Well, will you listen to this alternate version and tell me if there's anything wrong with it? Some men have bad intentions. On the night he attacked the victim, defendant showed his bad intentions. Do you see anything wrong with that?
I think that would be much better, and it would be much less similar to
Okay.
the Cawthorn language that the Supreme Court went out of its way to say, not only are we going to reverse this case, we're saying DAs in the future, this is the language you need to look out for.
All right. Would you agree with me that basically I substituted the word bad for evil and then intentions for heart?
Well, words matter. It matters which words they use, and it matters. So if the prosecutor had been more judicious and used words closer to what you said or what Your Honor said, I think that would be a lot closer. But opening with evil in light of Cawthorn, that specifically looking at the use of that word, really just seems like the prosecutor tempting fate and saying, okay, Cawthorn said I can't say it 15, but I'll try 3 and see if that works. And then maybe we get to 12 next time. And so that's where the problem becomes. Now, if the prosecutor had been more judicious and been like, I'm not going to use the word evil, I'm going to temper this a little bit and say bad intentions, fair enough. But he didn't. And that's what we're asking the court to look at. The argument that he made in this case, not a better argument that he should have made. Just real quickly before I have to go.
You have to go. You got about 30 seconds if you want to say one more thing.
So he's saying again that the evidence on attempted rape is just crystal clear and absolute. I cannot think of anything that would make this any different if the charge had been attempted aggravated sexual battery, for instance. Like, what makes this different? What makes this case different that they could say, oh, he had the explicit, specific intent to engage in penetration rather than just unlawful touching? There's no evidence about that. And that's what makes this case different and what requires reversal. So again, we're not saying that Mr. Simonds is a saint. We're not saying that he didn't behave badly in that room. What we're saying is the state did not put on enough proof to get a conviction of what they charged. And for that reason, we'd ask the court to reverse.
Thank you, Mr. Ridley. Thank you. Both will take the matter under advisement and issue an opinion forthwith. Call the next case, please, Madam Clerk.